Mr. Speaker, sir, my speech is divided into three topics. First, I will talk about the government's error in not realizing that Section 20 of the Criminal Procedure Code applies to TraceTogether data. Second, I will speak on the carving out of the 7 categories of offences in the bill that permits the use of TraceTogether data, and I will thereafter set out the Workers' Party's position on the bill. Third, I will look to the longer term and reflect on the balance between the privacy rights of citizens and the growing power of the state and private companies in collecting and using data and personal information. I believe there is scope to learn important lessons from the fallout that has ensued from the government's admission that TraceTogether data could be used for investigatory purposes, a departure from earlier assurances that TraceTogether would only be used for contact tracing. First, the government's error. Sir, Singaporeans are willing to take the actions necessary to combat COVID-19 when called upon by the government if they believe these actions will help our country and all of us who live and work here. A few Singaporeans have told me that if the government had stated up front that TraceTogether data would be used for the 7 categories of serious crimes only, they would have been prepared to prioritize the use of TraceTogether because of the imperative of fighting an epidemic. Even those who could have had residual privacy concerns could have been assuaged had the government detailed the processes and accountability regime for using TraceTogether information in investigations. Why was there disquiet, unhappiness, and even cynicism in some quarters at the government's belated acknowledgement that TraceTogether can be used for criminal investigations, as originally explained by Minister of State Desmond Tan in Parliament last month? It comes down to a question of trust, the perceived lack of empathy over the public's privacy concerns, and discomfort with sharing mobile phone data with the authorities without sufficient assurances. In fact, from a very early stage, the government clearly contemplated that there would be privacy concerns with the use of TraceTogether for contact tracing. In his broadcast of 21st April 2020, the Prime Minister said that Singapore intended to make full use of IT, including TraceTogether, which would require everyone's cooperation. He added, and I quote, "There will be some privacy concerns, but we will have to weigh these against the benefits of being able to exit from the circuit breaker and stay open safely," unquote. In the months that followed, the public were told that the number of sign-ups to TraceTogether was not satisfactory. As late as November, the multi-ministerial task force linked transiting to phase 3 in our fight against COVID-19, with requiring at least 70% of the population signing up for TraceTogether. Since then, and along with the issuance of TraceTogether tokens, this minimum 70% threshold was reportedly reached on 21st November 2020, even as it had been hovering around the 50% mark around 2 weeks earlier. When Minister Vivian Balakrishnan admitted in Parliament that he did not consider Section 20 of the Criminal Procedure Code at the next sitting of Parliament on the 5th of January this year, there are Singaporeans who opine that this was not fathomable or even believable for a largely efficient government machinery that has consistently approached COVID-19 as a whole of government endeavour. They further contend that if not ministers, at least the officials in the Ministry of Home Affairs, the Ministry of Health, and GovTech, who conceived of TraceTogether, would have known of the privacy considerations surrounding TraceTogether. Some go a step further in suspecting the government of willful blindness on function creep, or worse, that the information surrounding the use of TraceTogether for criminal investigations may have been suppressed until the threshold of 70% of the population had downloaded the app or collected the TraceTogether token. A separate group of Singaporeans query whether there will be consequences for those who made this mistake in promising wrongly that TraceTogether would be used only for contact tracing. They believe the government did not do its homework. While there was no dishonesty or malice, there was a lack of care or diligence in accurately communicating the potential use of data collected by TraceTogether. I am sure members have come across a range of opinions from residents in the course of their house visits or interactions with family and friends over the last few weeks on this matter. Whatever the view, it is apparent that the government's handling of this matter has eroded trust from some members of the public. To this end, I would like to ask two questions of the government, and specifically Minister. First, what was the exact date on which Minister in charge of Smart Nation knew that Section 20 of the Criminal Procedure Code would apply to TraceTogether? Secondly, and in connection with this, was Mr. Christopher D'Souza's parliamentary question submitted before or after the Minister became aware of Section 20 of the Criminal Procedure Code? These questions are important for the House to understand at what point the government determined that its original representations on the use of TraceTogether were misleading, and whether it could have corrected the position and updated the public on its own initiative. Let me now move on to my second topic, the carving out of the 7 categories of crimes and the Workers' Party's position on the bill. The Workers' Party's starting point on this matter is that Singapore is as close to a wartime scenario as most Singaporeans have seen in our lifetimes. This pandemic is exceeded in the living memory of older Singaporeans only by the far greater oppression of World War II. In terms of its effects on the national consciousness, COVID-19 is perhaps on par with other upheavals such as the 1964 riots and Singapore's ejection from Malaysia in 1965. Its scale and complexity have surpassed the SARS crisis of 2003. In such a wartime scenario, the core question for this House is whether the change in the government's position on TraceTogether data to allow for its use for serious crimes could compromise the fight against COVID-19 and jeopardize contact tracing. I will make 2 points in this regard. First, while we know that TraceTogether data is critical for contact tracing, we need to ask whether TraceTogether data is vital for solving these 7 categories of crimes. As it stands, the police have an abundance of investigative tools. They have other technological tools like CCTVs. They can forensically examine mobile phones and laptops that contain massive amounts of data other than TraceTogether. They also have old-fashioned police work such as finding and interviewing witnesses, using confidential informants, scrutinizing the crime scene, and collecting physical evidence for forensic analysis. There is a legitimate view that these tools should be more than sufficient in detecting crime and securing convictions. To know whether these other tools are enough, I would like to ask the Minister 2 questions about the use of TraceTogether data for actual cases. A, for the one known case where TraceTogether was used, was the case solved in that a suspect has been identified or charged? And how critical was TraceTogether data to solving the case? B, how many other times has TraceTogether been used for the 7 categories of serious crimes so far? There is little or no doubt that TraceTogether would make things more convenient for the police. But it is my view that convenience for the police may not be a good enough reason to compromise the trust necessary to win the COVID-19 fight. There is an equally legitimate view that with the existing tools at their disposal, the police are likely to have very little, if any, additional benefit from using TraceTogether data. I look forward to hearing the Minister's answers to my questions so that we can know for sure the answers will allow members of the public to appreciate the balance that is being struck between privacy and policing. On to my second point, would allowing these exceptions compromise the use of TraceTogether in fighting the pandemic? Against the possible benefits of using TraceTogether for fighting crime, we need to compare the likely costs to our fight against COVID-19. There was a public outcry after Minister of State Desmond Tan's reply on the 4th of January 2020, when Singaporeans found out that Section 20 of the CPC applied to TraceTogether tokens and applied to TraceTogether, and that the government had backtracked on earlier assurances. Some Singaporeans seemed placated when the government announced a day later that the use of TraceTogether data would be restricted to the 7 categories of crimes. Others less so. However, this House's knowledge of both support as well as resistance of Singaporeans is only anecdotal. In the middle of last week, it was confirmed that the TraceTogether sign-ups had reached 80% from 78% some weeks earlier. However, these numbers too can give a false sense of security insofar as our contact tracing efforts are concerned. In an Institute of Policy Studies report released on the 24th of May 2020, out of a broadly representative sample size of the Singapore population, 87% of respondents were agreeable to imposing strict surveillance on those who needed to be quarantined. But when the questioning moved to the employment of CCTVs and cell phones to prevent the spread of COVID-19, only 49% were agreeable to have their cell phone data tracked without their consent. Separately, a few people, or more than a few people I should say, have anecdotally shared online that they will use the TraceTogether app to gain entry to a place only to turn off Bluetooth immediately after entering. This clearly shows that a high level of downloads of the TraceTogether app does not necessarily translate to a high degree of continuous usage. Those who choose to switch off their Bluetooth function could do so for various reasons. A common one being that people do not want to drain their phone battery, and not necessarily because of privacy concerns. We don't know for sure either way, but if the IPS report is indicative, privacy is more than likely to matter. It is therefore open to question whether the efficacy of TraceTogether for contact tracing could be compromised because of the government's belated explanation on the use of TraceTogether data for investigative purposes. To that end, I would like to inquire if the government is able to track the number of users of the TraceTogether app who turn off their Bluetooth function after downloading the app, and separately, who turn it off after gaining entry to a building or premise. The answer to this question will determine whether TraceTogether is working as intended, or whether the government needs to comprehensively review the public buy-in and effectiveness of the TraceTogether app and token. I now move on to the Workers' Party's position on the bill. The Workers' Party is of the view that Singapore's #1 priority should be to tackle the pandemic's public health and economic effects. Anything that compromises this priority has to give way unless there are overwhelming good reasons. Other jurisdictions have taken a cleaner approach on contact tracing apps in line with the government's original public statements that TraceTogether would be limited to contact tracing, period. Personally, and subject to the Minister's response on the centrality of TraceTogether data for policing, I personally would prefer aligning the use of TraceTogether with the government's original emphatic assurances that TraceTogether would be used for contact tracing only. This is because of some Singaporeans' residual concerns over privacy and the established discomfort about sharing cell phone data. I am of the view that such an approach would also engender greater confidence, given that a public conversation on privacy has hitherto not been ventilated in a significant way in Singapore. I will return to that subject very shortly. Even so, the Workers' Party is prepared to support the bill to allow for the use of TraceTogether data for police investigations in the exceptional cases identified in the bill. The main reason is because the exceptions constitute a significant reduction of the wide ambit of Section 20 of the Criminal Procedure Code. In other words, a Singaporean's right to privacy is better protected with this bill than without it. Ms. Sylvia Lim will speak further on the 7 exceptions. Sir, let me move on to my last topic, which is about the longer term. The discomfort and distrust in some quarters generated by the belated disclosure on the applicability of Section 20 of the Criminal Procedure Code to TraceTogether is somewhat, or to some extent, unsurprising. A 2016 KPMG report shared that 32% of Singaporeans were extremely concerned about the handling and use of their personal data, and that Singaporean consumers felt the most defenseless among Asian respondents over the way organizations handle and use their personal information. I would contend that across the population there is a general lack of awareness about not just the government's powers of data collection, investigation and privacy, but the rapid advance of predictive technologies for public use. As a society, many are relatively uninformed about legal or constitutional rights and responsibilities, to say nothing about the right to privacy. If we are already talking about a societal COVID-19 reset when this crisis passes, the government should also review the lessons learned from the rollout of TraceTogether, and specifically whether Singapore should actively appraise the balance between policing and citizen privacy. The mobile phone application WhatsApp recently found out the hard way what happens when people suddenly become suspicious about technology and privacy. When the company published new terms of service with a short deadline for acceptance, there was a huge backlash against WhatsApp and its corporate owner, Facebook. WhatsApp's experience shows that Singapore's experience with the TraceTogether issue is not unique. Confidence in technological tools and the institutions that control them can be lost overnight. This loss of trust engenders cynicism and pushback from the public. And in an age where information travels instantaneously and fake news spreads at light speed, cynicism has to be taken very seriously and addressed squarely from a governance standpoint. In the first major debate of this parliamentary term, Prime Minister addressed the House on Disease X, a possible outbreak even deadlier than COVID-19. In this regard, a new national research program for epidemic preparedness and response called PREPARE was announced in December 2020. The program is meant to accelerate the production of diagnostic tools, therapies, and vaccines once a major disease strikes. However, medical preparedness is only part of the fight. The other part is the battle for the trust and cooperation of the people. If Disease X strikes and another TraceTogether type situation occurs, our fight against Disease X may be rendered ineffective and tragically thwarted. I call on the government to initiate an immediate conversation on the balance between the state's collection and use of data against the individual's right of privacy, because many of the new technologies with public repercussions have already been rolled out. According to the latest government financial statements, or GFS, the Ministry of Home Affairs has invested in PolCam 3.0 and 4.0, whereas only PolCam 1.0 and 2.0 have entered the mainstream media lexicon. Intrusive technology has already extended to other areas of governance. The government financial statements confirms that the Ministry of Social and Family Development has implemented video analytics, facial recognition, and behavioral analytics technology at a voluntary children's home. Let that sink in for a moment. Behavioral analytics technology at a children's home. What impact could befall a child if such data is hacked in a cybersecurity breach many years later? How is the problem of bias, both from a technology perspective and a human interface angle, dealt with? Who checks whether such information is secure or securely wiped? And who has a right to review this information, and for how long? To counter skepticism and its resultant behaviors and to replace it with trust and cooperation, Singaporeans also need to better understand the necessity and ambit of data collection. This is especially so for a new generation who are more likely to be concerned about privacy and individual rights. The public must also be assured that the data collected and used for investigative purposes have safeguards that are robust enough with independent and external checks and balances, if necessary. And it would be critical for the public to understand that in Singapore, at least, regulation is marching in step with the evolution of newer and more intrusive policing and data collection technologies. This is currently not the case in many parts of the world, and there is an opportunity for Singapore to be a leader in this regard. To this end, I would advance that there are important actions that the government can undertake to better dispel doubts. First, the government should be forthcoming without prompting in informing the public about what data it collects and how it ensures the robustness and integrity of its processes. Second, the government should ensure that our laws reassure Singapore citizens and residents that investigatory powers and data collection are used for legitimate purposes and are subject to rigorous checks that protect us from the abuse of our personal data. Moving forward, a review of our existing laws may be required to achieve this. Let me discuss each of these actions in turn. The first thing the government could do to counter cynicism and create trust is to be forthcoming about what data it collects and the safeguards to prevent misuse of information in its possession. The government regularly asks information of the tech giants like Facebook. For example, the Straits Times reported in 2018 that Facebook's semi-annual transparency report revealed that the Singapore government had made 244 requests for information concerning 310 Facebook accounts in the latter half of 2017. It would reassure the public, in my view, if the government could tell us what it has asked the tech companies for and for what purposes. This could be done on a regular basis through the police's annual report, for example. If the government is forthcoming with such information, it will engender confidence that the government has nothing to hide, is performing its role as a state should, and that its requests are for legitimate purposes in the interest of Singaporeans. Singaporeans would also better appreciate the nature of the behind-the-scenes work that is done to keep Singapore safe and secure. And I will make this point again. This awareness and confidence will aid us in our fight against future threats. The second thing the government could do is to conduct a broad review of the state's powers to collect data for the purposes of investigations in light of new technologies and consider how privacy concerns could be better balanced or accommodated within the legislation. Section 39 of the Criminal Procedure Code, for example, gives the police wide leeway when investigating arrestable offences to access computers and computer data, even for computers outside of Singapore. Section 40 of the CPC allows the public prosecutor to authorize the accessing of decryption information. Statutes like the Broadcasting Act and the Telecommunications Act and others give the police powers akin to those in the Criminal Procedure Code, although specifically scoped for those acts. Even so, like the Criminal Procedure Code, the investigative powers of the relevant authorities are drafted broadly and do not include separate laws on how the exercise of these investigatory powers come with safeguards. Such safeguards would reassure the public that the state is acting legitimately and with sufficient regard for the individual's right to privacy. To build confidence between the citizen and the state in an era where the call for privacy will only get louder, other verification mechanisms can be considered. I would offer 3 suggestions in this regard. One possibility for checking against abuse and engendering confidence can be the appointment of a neutral commissioner or an ombudsman to monitor the use of such powers by the government, and in particular, law enforcement agencies. Another possibility is an omnibus legislation like the UK's Investigatory Powers Act. This piece of legislation covers the acquisition and retention of data, including bulk personal data sets, and provides for how such material is dealt with, including oversight arrangements, amongst others. Thirdly, the government could include a key performance indicator in the budget book for each relevant ministry that measures the public's confidence in the collection and use of data collected on the one hand, and the public's right to privacy on the other. To conclude, Mr. Speaker, it is important for me to restate that privacy concerns are not the domain of a small segment of Singaporeans. The international conversation has moved significantly over the past few years, with recent revelations of how security agencies of democratic countries, such as the US, collect vast amounts of information about their citizens. Arising from such revelations, other democratic jurisdictions have sought to update their laws to focus on and better calibrate the balance between the state's investigatory powers and the individual's right to privacy. At the heart of this discussion is a desire for checks and balances that are fit for purpose for today's day and age. Understandably, the conversation with electorates in these countries has not been easy. Many people perceive the world to be in an Orwellian age, complete with fake news and the prospect of privacy intrusions by even private corporations. However, the absence of such a conversation in Singapore, combined with an erroneous assumption that continuing down tried and tested routes will suffice, would engender a worse outcome, even presaging a disunited population. We will all lose if that happens. COVID-19 is a crisis like no other, but insofar as finding a better balance between policing and privacy, the lessons that have been taught by this TraceTogether episode inform us that they are lessons the government would be wise not to dismiss. To recap, sir, the Workers' Party is prepared to support the bill, even as we look forward to the Minister's answers on the specific queries with regard to the police's use of TraceTogether data. And separately and arising from this episode, I urge the government to open a national conversation on privacy forthwith, with a view to not just prevent the weakening of trust between citizens and the state today, but to strengthen it for the Singapore of tomorrow. Thank you.
Madam Deputy Speaker, members of this House, let me first express my appreciation. My appreciation for, first, our points of agreement. I believe all of us are agreed and I'm looking at the leader of the opposition, I believe all of us are agreed that we are facing a global life and death crisis, which requires extraordinary measures. I believe all of us are agreed that contact tracing, effective, rapid contact tracing, is essential as part of our response to dealing with COVID-19. I also venture that all of us in this Parliament are agreed that TraceTogether and Safe Entry, representing our digital contact tracing tools, have made a real difference to the effectiveness of our COVID-19 response. And in particular, I would reiterate that it has enabled us to shorten the period from 4 days to 1.5 days. Members will know that I am by training and instinct a doctor. I'm not a lawyer, I'm a doctor. And perhaps one of the defects of being a doctor is that we focus very, very much on the individual, on their health, and on the outcomes of the individual. And I want to say that so that you understand in context, because what I want to do now is to share my personal timeline through this journey. And let me begin. We first stated that the government would use TraceTogether data only for contact tracing, simply because this was how and why we designed TraceTogether. I can tell you all categorically, again as a doctor and as perhaps a techno-optimist, that the potential use of the data by the police did not cross my mind or the mind of my engineers at all. I state that categorically. And in fact, if you think about the features that we built in, encrypted, decentralized data, auto-purging after 25 days, encrypted identities, no GPS, no cellular connectivity. I think any fair-minded person with some appreciation of technology will know that what we had in mind was digital contact tracing. If we were not at all trying to create a surveillance tool. I say this so that you understand my state of mind when I said what I said in June. But what I said in June was wrong, because in a sense, my own enthusiasm for the technology blindsided me, and I did not read Section 20 of the CPC. Because the law of the land is that the CPC, specifically Section 20, does authorize police to access many databases, including contact tracing data. The next point is, when did I become aware that what I said was wrong? And basically what happened was at the end of October, I was asked, are you sure that the CPC doesn't apply, even for a murder case? A member of the public asked me. When I received that query, I asked my staff, please go and double check. I'm not a lawyer, but please go and double check what the legal provisions are. At that point, I was informed that the CPC applied, and that in fact the police had requested TraceTogether data on one previous occasion. Your next question should be, well, what did you do after that? And I'll tell you very frankly, in fact, I've shared last month, I had many sleepless nights, and I engaged in several rounds of discussion with some of my senior cabinet colleagues on whether we should carve out, and if we did, how should we carve out the contact tracing data from the application of the CPC. You will know that my own strongly held view at that point in time was that even if the CPC applied, and even if we were going to make data available, we should exercise this with utmost restraint. I was also aware that I had first made this assurance in this chamber. I think it was in June, in this chamber. And I told my staff, regardless of the outcome of this internal review, we will come back here and we will clarify. And we did that last month. Mr. Christopher De Souza filed a question, I believe it was in early December, about a month after I commenced this process of internal discussion. I'm sharing this with you so that you understand that there is nothing to hide. The CPC is written law, but I should have been aware, and I should have made it clear right from the onset. You know, I've reflected that if in June I had added 4 words, subject to prevailing legislation, perhaps we wouldn't be here this afternoon. Nevertheless, it has occurred. So I want to, in the rest of this wrap-up speech, address the different queries and comments and suggestions under 3 categories. First, trust and participation in digital contact tracing. Second, the technical features and safeguards of TraceTogether and Safe Entry. And third, to deal with the specific clarifications of clauses within the bill. So, first, trust and participation. In an ideal world, no mistake would have been made. No question would have arisen. But I am now in a scenario where a mistake has been made. And the real question then is, how do we maintain trust when a mistake has been made? And I'll come back to my instinct as a doctor. The patient-doctor relationship is built on trust. Both the patient and the doctor hopes that we will never make a mistake. But mistakes do occur, sometimes, usually rarely. The most important ingredient in that trust relationship between a doctor and a patient is complete transparency, that if anything goes wrong, I will tell you. And if anything needs to be fixed, I will do so. And I will go all out to remedy the problem if I can humanly do so. So my answer to this question today, how do you maintain trust when a mistake has been made, is actually quite straightforward. Acknowledge the error, take full responsibility. It's no different from a complication in surgery. Acknowledge the error, take full responsibility. And I have done so. Next, do the right thing rather than choosing the politically expedient option. You know I believe in transparency, even if transparency is awkward and politically costly. But it is better to be transparent than to double down on a mistake. Do you see my point here? Better to be transparent, fix the error, rather than to double down on the mistake. One further principle from my medical practice is beware of false dichotomies. The false dichotomy I have heard today is that you have to choose between saving the life of a child and you have to choose between participation in digital contact tracing. I believe by being completely open, transparent, answering every question, explaining, and letting people see the purpose behind what we are doing and why we are doing it, I believe we can avoid this dichotomy. I believe it is possible for us to continue to have perhaps the world's most successful contact tracing program in the world, and at the same time, deal with people's expectations that Singapore will remain safe and secure, and that the police are our guardians, our protectors, and that the police have acted at all times strictly within the ambit of the law in order to fulfill their higher mission to protect us. So today, I come before this House, moving legislation on a certificate of urgency to give legal force to the statements that the Minister for Home Affairs and I made in Parliament last month. And this bill ensures that personal digital contact tracing data can only be used for contact tracing with a narrow exception for investigations and criminal proceedings in respect of 7 categories of serious offenses. I know there can be some debate, in fact, there has been some debate, how specific are our definitions? Should we enlarge it? Should we constrict it? I think that's legitimate debate. But I believe that this bill reflects the right balance between restricting the use of personal digital contact tracing data and at the same time enabling our police to fulfill their duty to keep us safe. Avoid false dichotomies. I will just reiterate a few scenarios which you have, in fact, in the annex in front of you. If the next of kin of a murder victim asks the police to please decrypt the TraceTogether data on his phone, would any of you refuse? If the parents of a kidnapped child found the token and desperately asked the police to unlock it, which one of you would refuse? If a terrorist act is imminent, would you tie the hands of our police and security forces? I believe I know the answer to these questions, and certainly by the majority of Singaporeans outside this House. Singaporeans understand the need for police to lawfully access information, and I believe that public trust in our police force remains high, very high. And as Foreign Minister who has had to travel to many parts of the world, this confidence and trust is a huge competitive advantage that Singapore has. On the question of public trust and public participation, let me, in a rather limited way, share some numbers with you. You know that for TraceTogether, we give people the option of writing in to say, please delete my data. In the last 1 month, we've had 350 individuals who have asked us to delete their data. 350. Every one of the 350 who has requested us to delete is a source of regret for me, because at least 350 have, for a variety of reasons, decided to forego the protection that TraceTogether offers them and their loved ones. But on the other hand, in this same period, in this same 1 month, over 390,000 390,000 have come on board the TraceTogether program. I don't want to belabor this, but my simple conclusion or inference is that Singaporeans know that I misspoke, but they also trust the TraceTogether system is safe. It does what it is supposed to do. It protects public health, and they also trust the police to always behave lawfully. Members also had questions on the features and safeguards of TraceTogether Safe Entry. Let me quickly try to run through as many of these clarifications as possible. I think Mr. Lewis Ng, I think Mr. Pritam Singh as well, asked whether it has affected our adoption, and I've just given you some figures on people who have signed on in the last 1 month. But I will also accept the point that Lewis made, and I think Gerald Giam made as well, that there may be individuals who are gaming the program. You switch it on in order to do your safe entry, and then you promptly switch it off. And I think Lewis Ng also asked whether we have more granular data into how people are using the tokens and using the TraceTogether app. You know, today, more than 80% of Singapore residents are on board the program. Based on broad proxies, and I say proxies, and I will explain why it's only a proxy. But based on broad proxies, we estimate that about 58% of users use the app at least once a day. And this proportion has remained the same before and after the parliamentary clarification in January. Mr. Ng also asked if we could provide more granular usage statistics, such as whether the mobile devices applications were on average pinging fewer devices than before. And Mr. Ng, I have to tell you, actually, the privacy-respecting nature of the system means we actually cannot collect that level of granular data to track active usage. The data is stored locally on your own device. The TraceTogether app only connects to the server periodically, only to download information, and some members will be familiar occasionally when you've checked into the same place as someone else who has turned out to be COVID positive. That message may light up to warn you that there may be a potential overlap in time and space between you and a COVID positive patient. The point I'm making is that, again, it reveals the privacy by design that we focused on in rolling out this program. And I want to remind everyone that TraceTogether is meant to protect us and our loved ones. The effectiveness of TraceTogether depends heavily on the rate of user participation. And for those who switch off your Bluetooth or your app or engage in other forms of technical wizardry, I would just ask you, why? Why deprive yourself and your loved ones of the protection? Again, as FM, I've looked around the world, and one of the reasons why we are better off is that we have not politicized our response to COVID-19. And I'm grateful to Mr. Singh and the Workers' Party that, unlike in other countries where wearing a mask or not wearing a mask is a badge of political identity, we have avoided that kind of political dichotomies. So for people who are angry or disappointed at my mistake, you're entitled to do that, but don't deprive yourself and your loved ones of the protection from this system. Ms. Nadia Samdin asked a few suggestions regarding OpenTrace, and she asked if we would continue to make OpenTrace open source such as by introducing open source licenses and regularly updating the GitHub repository. Actually, my engineers will know that I've been leaning on them repeatedly to keep updating the GitHub repository. But again, those of you who are actual programmers will know it is a very big slog to tidy up your code and prepare it for public open source perusal. But we believe in open sourcing, the open trace. It has served us well. It has been helpful. It has allowed experts to look at both open trace and TraceTogether, and for them to conclude that the app does and continues to do what it is supposed to do, and to do so in a privacy-protecting manner. Other governments have looked at our code base, including Australia, Alberta, Poland. We've had discussions at a technical level. They've modified it, used it, changed it. We are completely open about that. To be clear to Ms. Nadia Samrin, there is already an open source license. The Open Trace repository is published under, sorry to get technical here, but it's published under a GNU General Public License version 3.0. Those of you in the know will know that this is an open source license. The standard General Public License 3.0 terms are also within the repository itself in a license and markdown file, as is the standard practice, and maybe Nadia can check on that after this. But I will convey our suggestions to the GovTech team and discuss what our next steps are for open sourcing. Ms. Nadia Ahmad Samdin also asked if we would commit that TraceTogether data will always be stored on the user's device and shared with MOH only when the user uploads the data, and to delete the data at the request of the user. By design, TraceTogether data will be stored in the user's device before it is shared with the authorities. And again, for those of you who've ever been in the circumstance where you need to share it, you know that your participation is needed. We send you a PIN, you have to enter the PIN before the data is uploaded. This bill limits the government's use of TraceTogether data to the purposes of contact tracing, with the exception, as I said earlier, for investigations and criminal proceedings in respect of serious offenses. And it applies regardless of how the data is accessed or shared. The same applies for the suggestion on deleting the data upon request. Users can do so. And we have done so, as I shared just now. We have deleted data for 350 persons in the last 1 month. But in certain cases, for instance, where the data has already been uploaded because there was a positive COVID case, then MOH will have to retain that data as long as that cluster is active, and they need it in order to break the chains of transmission. And I'm sure members of this House will understand the need for that. Mr. Gerald Giam asked about the police use of safe entry data. I believe you did ask just now. I'm not privy to the operational details, but I do understand that safe entry data has been used for investigations into offenses in a number of instances. And I must state for the record that my previous assurances were on TraceTogether in this House and not on safe entry. Nevertheless, we have decided in this bill to envelop safe entry and Blue Pass insofar as it interoperates with TraceTogether within the same protective cocoon that this bill provides. What it does, it's also worth reminding members of the House that actually safe entry is a digital visitor log. It's no different today. If it wasn't there, the police would go to the security guard, say of your condominium, and say who has come in at what time, which car numbers were in here, look at your video surveillance. So safe entry actually in that sense is much less, is not novel compared to TraceTogether. But it is different in the sense that it is a centralized database. And therefore, we decided we better take preemptive action to put the same cocoon of legislative protection around it. Let me now move on to clarifications on the legislative amendments itself. And I hope members will bear with me if some of this is a bit technical. Ms. Nadia Samdin asked if an individual would be able to access their own personal contact tracing data, including if one is being charged for a serious offense. The answer is yes. Members of the public can request for their own data for legitimate purposes, as is the current practice today. The lawyers looking at the text of the bill will realize we've been very careful not to circumscribe the rights of the individual to his data. I believe Ms. Sylvia Lim asked if suspects and the defense counsel could access the personal contact tracing data for their court cases and whether the time period of 25 days is sufficient to retain the data for such users. I hope yes. The bill circumscribes the use of personal contact tracing data by public sector agencies, but I will reiterate, does not prohibit individuals from using or requesting for their own personal contact tracing data, provided they have a right to access such data. For serious offenses, the individual can share his or her own data with anyone, including the police, the prosecution, the defense counsel, and offer his or her data to the court as evidence. If the prosecution is in possession of contact tracing data which strengthens the defense case or weakens the prosecution's case, the prosecution has to disclose such data to the defense to comply with its common law disclosure obligations laid down by the Court of Appeal. I believe this is known as the CADA disclosure obligations. Again, the criminal lawyers here will understand what I'm talking about. This is in the bill. Specifically, Section 82, subsection 7, allows for individuals to continue to have access to personal contact tracing data if they have a right of access under any rule or otherwise. Mr. Singh, you can confirm that clause. The right of access under any rule of law here includes the CADA disclosure obligations. Ms. Tin Pei Ling asked if TraceTogether data could be used in missing persons cases. A next of kin, father, mother, husband, wife, a next of kin may request the data of a missing person to the extent permissible today. This includes requesting for personal contact tracing data of the next of kin if they have a right to do so. Mr. Gerald Giam also asked if personal contact tracing data uploaded to MOH servers will be covered by this bill, specifically by Section 82. The answer is yes. The bill restricts the government's use of personal contact tracing data collected from digital contact tracing systems specified in the 6th schedule. Mr. Zulkarnain Abdul Rahim suggested having a dedicated channel independent of the police to investigate any complaints or TraceTogether data access breaches made by any party. If you peruse the bill in front of you, you will realize that disclosure or misuse of contact tracing data or contravention of the COVID-19 Temporary Measures Act will be investigated by an authorized persons from the Government Data Office appointed under this Act. These authorized persons will be appointed by SM Teo Chee Hian as the minister overseeing this part of the Act. So there is a clear separation of roles and duties. The Government Data Office will oversee the public sector data governance policies and requirements, similar to what the PDPC does for the private sector. And I can give this assurance that police officers will not be appointed for this purpose. There were also other questions pertaining to data governance for personal contact tracing data. I think it was Mr. Yip who asked whether police would still be able to request the data beyond the 25-day mark. And if the data will be stored for more than 25 days, should it be required for police for investigations or proceedings into serious offences? I think it was also Mr. Giam who asked if police will be able to access the data when the pandemic has been declared over. In general, the police will not be able to obtain data if the request comes in after the 25th day mark, and this is because the data would have been auto-deleted, either deleted on your personal token or app, or deleted from the main server. There are some exceptional scenarios. Nowadays, I'm very careful with all my caveats. There are some exceptional scenarios where data may be stored for more than 25 days. One, when the data relates to a COVID patient or an individual who is closely associated with the patient, and the data is used for active contact tracing purposes. And I think that people will accept is a legitimate use of data beyond the 25th day. Two, when the data has been used for investigations or criminal proceedings in respect of serious offenses, the data may be retained until the investigation or criminal proceedings are over, including court proceedings, I must add, and will be deleted when the data is no longer needed. The same applies to when the pandemic has been declared over. And then we can happily stand down our digital contact tracing programs. As I mentioned in my opening speech, subsection 82(8) provides for the minister to specify a date after which the digital contact tracing system is no longer required to prevent or to control the spread of COVID-19. The data administrator must then delete any personal contact tracing data which is no longer required. Police will not be able to use any personal contact tracing data unless the data had previously been retained and used for investigations or criminal proceedings in respect of serious offences. Ms. Nadia Ahmad Samdin asked if the government would consider publishing disclosure reports to help the public understand how the data is being used. We will accept Ms. Nadia's suggestion to have a report disclosing the use of the data beyond contact tracing. My team will work out the details on how often and the content of these reports. But it should broadly encompass the types of data, how the data was used, as well as the number of occasions that the data has been used for purposes other from contact tracing from the day that this act comes into force. Ms. Nadia Ahmad Samdin and Mr. Gerald Giam asked if it was possible for us to specify the conditions for the life cycle of the TraceTogether program, such as the conditions to decide when it should be deactivated. Actually, this is a much wider question. What determines the changing points in the pandemic, and what determines the end of the pandemic? Our approach has to be guided by science and public health. We will monitor the overall situation closely, consider all relevant factors before adjusting our measures, as we have indeed in the last 1 year with our 3 phases of reopening since the circuit breaker. In other words, there is no rule book. There is no standard playbook that we can rely on. We will have to respond to the situation as it evolves. And this approach has served us well, and we should continue to abide by this considered approach in determining the end of the pandemic. Even now, we know that the pandemic has been very unpredictable. Many places that previously contained the initial infection are now dealing with second, third, fourth waves. New variants have emerged, some more transmissible, some even more lethal. Whether and when we can revert to normal will really depend on the global situation, not just the situation within Singapore. And this is the nature of infectious disease epidemics. Lastly, members expressed a wide variety of views on the types of offences which police ought to use personal contact tracing data for investigation of criminal proceedings. Some of you suggested expanding the list, some to include additional offences. Mr. Vikram Nair, I believe, said that he preferred not to have any carve-outs, he said that this would be tantamount to saying that the police should not look at all available information in pursuit of their investigations. Mr. Shariel bin Mohammed Taha, Ms. Tin Pei Ling, Alex Yam, Chris D'Souza expressed concerns that the passage of this bill may set a precedent for how the government may use data collected by digital solutions in the future and hamper the government's ability to function effectively. Mr. Pritam Singh, in his considered speech, also referred to the future and what impact these decisions may have. I want to say that our decision today to only include serious offenses, to tightly scope the use of personal contact tracing data, is a result of a delicate balance between the right to public health, the right to public security, and respecting the sensitivity of personal data during this extraordinary time. Madam Deputy Speaker, this bill is being tabled and read on a certificate of urgency in exceptional circumstances. It is intended to deal with a specific issue of the government's use of personal data collected via digital contact tracing systems in the midst of an emergency. And we have taken this exceptional step because we need to focus on encouraging public participation and maintaining confidence in our public health measures. This bill is about ensuring maximum support from the public in our fight against COVID-19. I want to stress this bill is not a precedent. It is not in the public interest to deny the police access to data necessary to ensure public safety and the proper conduct of justice. The nature of the legislation which this House is called upon to consider today is sui generis. It is a piece of legislation introduced during a public health crisis being moved under a certificate of urgency because of the situation that we are in. We are not trying to set a precedent here today. Privacy and data governance, especially in the face of accelerating technological revolution. These are broad and complex issues, which I think Mr. Singh also recognizes, that need careful contemplation, consultation, and open debate. This should not be settled on a certificate of emergency in one day. There will be proper occasions in the future to do this. Madam Deputy Speaker, our response to COVID-19 has not been perfect, but it has been effective. This current state of affairs did not happen by chance. It is due to our concerted efforts on multiple fronts. Our excellent healthcare system, our heroic frontline officers, our extensive testing capacity, our effective contact tracing regime that has enabled us to quickly identify, isolate close contacts, truncate transmission. Most of all, it is because of our social capital, the sacrosanct trust of our citizens, and the collective responsibility that we have for one another.